Good afternoon, good evening, good morning, depending upon where you're from. Welcome. I am Janice Kaminer-Resnick, and I welcome you on behalf of the members of our leadership team, which aside from me includes former Congressman Mel Levine and former Los Angeles County Supervisor Zev Yaroslavsky. Special welcome and thanks to our guest tonight, Andrew Weissmann, and to our wonderful interlocutor, Patt Morrison. As unpleasant as the topic of Trump's liabilities might be, and as much as we might not want to hear about these legal woes and sagas, this subject is very important. It's a critical subject and a critical variable in the upcoming presidential election. So we are eager to hear Andrew's take on the current state of the various Trump indictments, trials, convictions, and appeals. His recently released book, which I will hopefully capture here in my camera, is called The Trump Indictments. It's got amazing commentary and introductions. He wrote it together with his New York University Law School faculty colleague, Melissa Murray, and I highly commend it to you. As you all know, tomorrow night is the presidential debate, and next Monday, we've added a program with two incredible experts to analyze the debate content and the performance of both candidates. Monday, July 1 at 5 Pacific, we will welcome Peter Baker, Chief White House Correspondent for the New York Times, with UCLA's Lynn Vavreck, a professor of American politics and the author of definitive books on the 2012 and 2016 presidential elections. They will be in conversation with Larry Mantle. It will be a wonderful hour. It is our only program next week. We'll be back after the 4th of July on July 10th with an Israel-oriented program at which Professor Steve Zipperstein of UCLA will discuss the international legal aspects of the war in Gaza. Be sure to continue to save Wednesdays 5 to 6 for the indefinite future. We have an amazing lineup planned for the rest of the year. Reminder, all of our programs are available via podcast and via our YouTube channel and on our website. Links to all of our past programs are in every email we send. If you go to any email and look for it, you'll find the links. So try to do that before you email and ask me for a link because they're right there. Now to introduce of course, if you can't find it, do email me and I will make sure you get the link. Now to introduce our speaker and moderator, please welcome my friend, a member of our leadership team and my colleague, former Congressmember Mel Levine. Mel?
Hi, Janice. Thanks very much. It's a great pleasure for me to be able to introduce Andrew Weissmann, our speaker this evening. Andrew has the title of Professor of Practice at the New York University Law School. It's certainly appropriate because he certainly knows practice. He's had an extraordinary practice career. It would be impossible to do justice to try to describe all of it, but a few of the highlights I think are significant and worth noting. Among these has been his service as chief prosecutor in Robert Mueller's special counsel office and chief of the fraud section at the Department of Justice. He was also general counsel for the Federal Bureau of Investigation. He was director of the Enron task force, where he supervised the prosecution of over 30 individuals, and was a federal prosecutor for 15 years in the Eastern District of New York. He served as chief of the criminal division, during which time he prosecuted numerous members of the Colombo, Gambino, and Genovese families, including the bosses of the Colombo and Genovese families. He's no stranger to high-stakes prosecutions. He was also a partner at a highly regarded international law firm. As Janice mentioned, he recently came out with this book that Janice showed and that I'm pleased to show also, and I also commend it to our audience. He, along with Melissa Murray, the name of the book is The Trump Indictments, the Historic Charging Documents with Commentary. On a personal note, I thoroughly enjoy and am very grateful for Andrew's consistently thoughtful and incisive analyses that we receive on MSNBC. I believe in doing these that he is performing a critically important public service for which I, and I know many others, are extremely grateful. This evening, our interviewer will be the indefatigable Patt Morrison, who is a writer and columnist for the LA Times, whereas a member of two LA Times reporting teams. She has a share of 2 Pulitzer Prizes. She is a beloved and much sought after host on a variety of public television and radio programs. She has received 6 Emmy Awards and a dozen Golden Mics among her many awards. And last year, the Society of Professional Journalists, Greater Los Angeles chapter, conferred their prestigious distinguished award on none other than Patt Morrison. Pat, the floor is yours.
Mel, thank you. And thank you, Janice. And thanks to everyone who watches and supports this vital program, which has been going on for, well, more than 4 years now, brought to the internet, brought to your computer by the force of COVID, but now brought around the world, and some of the most astounding thinkers that we have in the United States today, Andrew Weissmann being one of them. Thank you. Welcome to your first session at America at a Crossroads. We hope it won't be your last.
Thanks so much. It's great to be here. I was just, it's incredible, the list of people and where they're from. I was thinking about the Gulf Stream waters to the Red Forest, but this is actually even further than that.
To the Barrier Reef.
Exactly. So it's wonderful to have such a wide community to discuss this topic.
Well, I think the subjects we're discussing today have worldwide repercussions, and
absolutely,
we're certainly going to get to that. It was 1 month short of 50 years ago that the U.S. Supreme Court told President Richard Nixon that his claim for immunity for his Watergate crimes wasn't going to fly. And a couple of weeks after that, Richard Nixon resigned. We find ourselves with a different president claiming his own immunity, and a Supreme Court that has put off, unlike the Supreme Court of 50 years ago, which acted quickly, put off telling us what decision it will render. So maybe we should start with just a sense about that delay, about kind of the clumsiness we're seeing with the Supreme Court, a decision being posted briefly on the Supreme Court website and then taken down, drip, drab decisions coming out. But the big one, as we wait for the decision and for the debate tomorrow, is on the Trump immunity claim. Can you tell us where that stands?
Sure. So I'm going to sort of address that small bore and then maybe big picture take on that. Small bore is, it's typical for the court to finish announcing all of its decisions by the end of the term, which is in June. Every now and then, it makes an exception and sort of slops over to July. We know that it typically issues those decisions on Thursdays, but for the last couple of weeks, and this week is no exception, the court has said that it's going to issue decisions on other days as well. So it was today, tomorrow, and Friday are all dates that the court said it will issue decisions. It has also indicated it may do that on Monday as well. It seems pretty unlikely to me that it's going to issue its immunity decision tomorrow, the day of the debate. I mean, it's possible, they've acted quite strangely so far, but that seems like a bridge too far to tackle that and have it viewed as so politicized if it does that. So that sort of, to me, leaves Friday or Monday as the most likely. But the big picture here is, I think, not so much what's going to be in the decision, because it seems inconceivable to me that they will say that a president is categorically immune from criminal prosecution for all activity. But we really have the decision with respect to Donald Trump, because the de facto decision is that he is not going to see the inside of the DC courthouse, I think, before the general election. Obviously, if he is not elected, that case will go forward in front of Judge Chutkan. But I really think that the public's right to a speedy trial, because remember that is a right that the defendant has and the public under Supreme Court precedent, that I think that has been denied, that the public could have seen this months and months ago. Remember, Jack Smith asked the Supreme Court to hear this case 6 months ago in December. And if the Supreme Court felt that it really needed to put its stamp on this legal issue, it could have decided, Pat, just as you said, just as the court did almost 50 years ago, and it certainly has very, very expeditiously. And I think if you think about sort of where we are as a country, I very much think about this sort of globally. I think if you think about how the courts have fared in terms of handling holding a former president to account, I think we've done pretty dismally. I think that Morrison, the state judge in New York, has done a terrific job. I would give him sort of an A+ in terms of getting that case to trial, in terms of fairness, in terms of the way he handled the case. But I think if you look broader to the other cases, whether it's DC, Florida, or Georgia, you really can't say that we have done as well as many, many other Western countries that have had similar situations and have managed to get through it in a much better fashion. And so I think we're really behind the curve.
Your MSNBC colleague, Lisa Rubin, said delay is decision.
Yeah. That's absolutely right. I mean, here you may very well get a very flowery decision that talks about how presidents are not above the law, and that no man is above the law, no woman, and it says all that. But de facto, what they will be doing is saying this former president is, or at the very least, they're saying that we are wiping clean. We're sort of taking off the table any political repercussions that would come from a trial and from what happened on January 6th. And so although there were the January 6th hearings, there is a lot of evidence that we have not heard. For instance, the Vice President of the United States, by all accounts, has gone into the grand jury and testified to Jack Smith's prosecutors, and that evidence from White House counsel, a number of people, has not been made public, and it would be very beneficial for the public to hear it. And just to be clear, what's so odd here is that what I am saying and what the prosecution has wanted is to give the defendant his day in court. In other words, it's with all of the legal rights that a defendant has, the rights to discovery, the right to cross-examination, the right not to take stand if you don't want to, and the jury can't hold that against you. And so you have a defendant saying, no, I don't want a trial. Well, that's not a right that is supposed to be recognized. No defendant really wants to go to trial, or let's just say it's the rare defendant who wants that. The courts, however, are required to hold speedy trials.
The Supreme Court 50 years ago acted so expeditiously, and because of the long delay in this decision, people are naturally putting it in the context of what they're seeing about Justice Thomas, Justice Alito, some of the things they have said, Justice Alito's wife flying the upside-down flag, Justice Clarence Thomas' wife in communication with the White House Chief of Staff in the Trump administration on January 6th. Is the delay accountable, do you think, for some new consideration beyond what the court did 50 years ago? We've seen that this court is not reluctant to end precedent. What accounts for the delay, and is there any sense that some faction is trying to give some wiggle room here, or to, in the case of Chief Justice Roberts, give this court, which is under such suspicion from the public, some great gesture of probity that it certainly needs at this point?
I am very, very cynical in terms of this is educated speculation on my part as to how to read the delay. But there's no question that the court had many ways to deal with this on a much faster basis. For instance, they could have taken the case in December. They could have not taken the case at all, because this is one where, I mean, let's just back up for a moment, because we're having this very rational, civilized discussion. But just remember what the position is of Donald Trump, both in the Court of Appeals and in the Supreme Court. I can order SEAL Team 6 to kill someone, and that is something I would be immune if I ordered that. That is so preposterous that there's a reason no one has ever made that argument, because no current or former president would ever think that. Frankly, no current or former president has ever thought they should be immune from criminal prosecution. That just is, it's not in the Constitution at all. And so for originalists on the Supreme Court, this should really be anathema to them. So with all of that, it's very hard to see that there are 5 justices who were took so seriously the right to a public trial to get this case moving, that there clearly are not 5 justices who would move this along and say, you know what, we're not waiting for your dissents, we're not waiting for your concurrences, we need to go. A second thing they could have done, if they couldn't get that sort of group together, the reason that we're in this bind is because there currently is a stay of the district court proceedings. So the district judge was 80 days away from her trial date of March 4th, when the case was stayed in December. If the court had said, you know what, we're going to lift the stay, not for the trial, but you can start doing all of the pretrial proceedings, that would have meant that when the decision is issued, let's say on Friday or Monday, the case would be far along in terms of getting it ready for trial, as opposed to now, if there is a green light to go forward, the district judge has pretty much committed to that 80-day period, because there still is so much work that needs to be done, including by the defense, to simply prepare for the case. And so there were just lots of ways that the court could have sped this along. And so it's very hard to see this as that the delay itself isn't the political result that the court, at least the majority of the court, wants.
Even if the court were to issue its decision on Monday, that would still mean October for the earliest start for a trial date. And of course, people would say the fix is in because it's too close to the election.
Exactly. Now, I will expect that Jack Smith will make an argument that he is prepared to slim down the indictment, that it's so-called slim to win, and that's all usually not a bad strategy as a prosecutor. I'll tell you one quick anecdote. I remember going to Chief Judge Weinstein in the Eastern District of New York, very, very eminent judge, and he asked how long our trial was going to be, and we said it would be 2 months. It was the boss of the Genovese family, and he said, no, your trial is not going to be 2 months. And we said, okay, Judge, how long is our trial going to be? And he said, well, let's see, 1 month. And you know what? That was the best thing that ever happened to us, was forcing us to sort of cut down to what did we need and not put in extraneous material. And so I do expect that Jack Smith will make a last-ditch effort to say that 80 days can be shorter, because he's willing to narrow the charges to the most important and salient things. So I would expect that. I'm not sure it will succeed, but I think there'll be some effort to try and cut down the 80-day period.
We have a lot of questions coming in about the ethics of Clarence Thomas and Justice Alito, and we'll be doing that a little later in the program, so we can address that in bulk. But I think people would also like us to move the story down to Florida about what's happening there in Judge Cannon's courtroom, which, with the New York Times story of last week, that a couple of senior judges got together with her and suggested that she really needed to pass this torch to someone else, that it was beyond her experience, her capability, and she refused to do that. How rare is that, and what does it say about what those judges' concerns were?
So, that's one of those things that I think is probably extremely rare, but I don't know that we'd ever hear of it. But I just can't imagine that happens all that often. I also can't imagine if I were a new federal judge and the chief judge of my district asked me to really think about whether it was right for me to sit on it, that I wouldn't readily accede to that. And the reason is this is not about you. This is about the institution of the court. And if the chief judge of your district is saying, look, you're going to be a great judge, but you're new, and this is a very high profile, very high sensitive matter. It involves classified information. It really would be better for it to be handled by a more experienced person. It really seems surprising to me that somebody wouldn't really take that to heart. Let me give you a data point that I think again, I'm very cynical about her actions. And here's a data point that I think is a tell in evaluating her. At least for me, it's a tell, which is every federal case is assigned to a judge and to a magistrate judge. And a magistrate judge, I've analogized it to like a sous chef. It's somebody who is there to help the judge in all sorts of ways in deciding motions. They do a lot of discovery motions. And so they do a lot of the legwork. Here, Judge Cannon, while she has said, I can't possibly give you a trial date because I'm so inundated with work that I haven't gotten to. And so she's sort of very, very slowly going through the various motions, but she has not assigned a single thing to the magistrate judge. Not one thing has been assigned to the magistrate judge to handle. So if you're so inundated, why are you not handing that off? And I think the answer has to be, I think, twofold. One, because she's not interested in speed. And two, I don't think she's particularly interested in the magistrate judge disagreeing with her. And the magistrate judge is extremely experienced, has been on the bench for years. And if she has a view that she's going to want to do X, she also seems like she's not secure enough to give it to a magistrate judge. And she's always, by the way, able to, with the magistrate, you can always overrule the magistrate and say, I disagree. But it's a real tell to me that she has taken that position.
Have you ever seen that before? What reason would anyone offer for not accepting what seems to be a standard piece of courtroom strategy for a judge?
If the case was simple and relatively small, you can imagine a court saying that the district judge saying, I'll handle it myself because there's not that much to do. When there's this much to do, I'm trying to think of a time. It's usually the reverse. You're usually in the situation where almost everything is getting handed to the magistrate, and you're sort of rarely seeing the judge until the trial starts. So, I don't see a particularly legitimate reason here for that to happen. You can throw into the mix on that. You remember, this is the district judge who assigned a special master to help in the pretrial phase. Remember when she allowed Donald Trump to sort of litigate when he was not even charged, and she brought in a special master who was, I've never heard of a special master who was another co-equal judge. It was Judge Deary, who I know very well from the Eastern District of New York. And then she treated him terribly. Anytime that he did anything that she remotely thought was favorable to the government, she then overruled him. And the whole thing seemed preposterous to me. First of all, there was no reason to have a special master, and she got reversed on that ground. The 11th Circuit reversed her not once, but twice, saying that you have no business giving Donald Trump any extra rights that any other defendant would not have it. And two, there's no authority to appoint a special master. And three, you cannot preclude the government from doing an investigation into the classified documents, all of which she had done.
She doesn't seem chastened by any of this. Just last week, she was questioning how much money and where the money came from that the special prosecutor prosecutor was operating on. Indeed, whether the special prosecutor was legitimately appointed, which is something that, as far as I know, has been settled for a really long time. And at one point, it sounded like she was a member of a House Budget Oversight Committee asking about how many millions it costs to maintain the special prosecutor.
So this is an issue I know very well because when I worked for Special Counsel Mueller, this was litigated in front of a variety of judges at the district court level. It actually went to the Court of Appeals, and all of the judges, whether they were nominated by a Republican or a Democrat, all of the judges said that this is constitutional and there's no issue here. Just remember, by the way, there are special counsels that looked at Joe Biden's classified documents. There's a current special counsel with respect to Hunter Biden. And so there were special counsels appointed by Bill Barr. I mean, we've had a whole series of special counsels. And I just want to make a quick point because one of the district judges who said this is constitutional is Daphne Friedrich, who is a district judge in Washington, D.C. She was nominated by Donald Trump. She was confirmed by the Senate, and she is a thoughtful, smart judge. And one of the things that is so disheartening about Judge Cannon is that it makes it so relevant to ask, well, who nominated this person? And it's so unfortunate because there are really good judges who take their oaths of office seriously. And whether they're appointed by a Democrat or a Republican, they do their duty. And here we have just such a great contrast between Daphne Friedrich and the way she handled this and her really thoughtful opinion about this issue, finding it all constitutional, and Judge Cannon, who is basically reinventing the wheel on an issue that's decided and using it also to slow down and to gum up the work so she doesn't have to have a trial before the election.
Seth asks, and I'll interpose this right now. There have been a number of complaints by individual citizens about Judge Cannon, as well as Alito and Clarence Thomas. And he said, basically, you file a complaint letter, send it by U.S. mail. Is it worth the effort and postage? People are really quite upset by the spectacle in a courtroom in Florida.
I'd say obviously it's great to have your voice heard. There are many ways to have your voice heard. I don't think that's a bad way. It doesn't hurt, but I also think that it's really important to, if you are concerned about the integrity of the judiciary, where there's, that's one of our last institutions and bulwarks of our democracy. They're, getting involved with your local representatives, in terms of state judges, being involved at the federal level and voting are really important. It's really important for people to understand that this is an issue that you care about, that in other words, many people have pointed out that Republicans, and I don't mean this as a criticism, have been very focused on the court and advancing their agenda with respect to the types of judges who would help them in terms of their agenda. And so if you think that is not what your particular views are not being advocated, then getting involved is the way to do it, in the way that a lot of conservative people have done, and making it very much a voter issue. And my colleague Melissa Murray keeps on saying this, which is the Supreme Court is on the ballot. They're just, if you didn't think it before, Roe versus Wade being overruled after so many years if that's not the clarion call for people who think that's a fundamental right, and that this court is poised to do more damage, then there's really nothing that will wake people up. I should say the decisions that you're referring to, Pat, just that came out this week and last week, are so ominous because in many ways they basically kicked the can down the road. Justice Ketanji Brown Jackson basically said as much in the decision that sort of came out and then was withdrawn, and her concurrence / dissent basically said, you know, this is really ominous for women in Idaho because the court is not saying anything about the merits of this. They're just saying we're not going to decide it now. And so what that is saying is we're going to see who wins the election, and we're going to decide it at a time that it is not going to be a political lightning rod in terms of getting the vote out.
A couple more questions about Judge Cannon, and then we'll move back up to the Supreme Court and get to some of our questions. Is this a case of someone who just has a case of nerves, that she's in over her head, she's new to all of this, and she's bringing up settled law, presumably settled law, just to make sure that she's got everything nailed down? Or more cynically, maybe more sinisterly, people see that this is entirely politically motivated on her part?
So, you know, my view of that is it's both, and that you know, there were a lot of people who commented on the fact that she allowed amicus briefs and amicus argument, that is sort of friend of the court briefs. That's very, very unusual to not just allow them, but to allow argument at the district court level. But you know what? That didn't bother me that much. I didn't view that as partisan. I just viewed that as really inexperienced, and that she might just be nervous. And there are other things where you can see the way she handled something. She also seems to be fairly thin-skinned, which is not a great attribute for a judge, where you want, you know, you really want this judicial temperament and to be equanimity. You want control of your courtroom, but that's obviously something she's going to have to work on. But there are other things that we've talked about that I think are signs of partisanship. I mean, she was, again, just to go, you don't have to get into too many details. She was reversed twice by a very conservative 11th Circuit. And one of the things that they said is, you said that you're doing this in part because he used to be president of the United States. And the 11th Circuit said, that's not how our law works. That is anathema to the oath of office that you take as a judge, that people are treated equally. What your former job was does not mean that you suddenly have more Fourth Amendment rights than anybody else. As Chief Judge Pryor and as Judge Chutkan have said, he is citizen Trump now and is entitled to all of the rights, but no more than the rights that every citizen has.
And so many people have wondered whether Jack Smith is, at this point, has any possibility of getting her tossed off the case, or does this have such a big backfire effect that it becomes counterproductive?
I still think there is a possibility that that's going to happen. I don't think it'll happen in time for the case to go to trial before the general election. I think that one of the things that Judge Cannon has tried to do is steer clear of decisions that will get her reversed for a third time, because, you know, at some point the 11th Circuit, when the risk is the 11th Circuit can just on its own reassign the case. And so there are pending motions that if she were to decide them adversely to the government has a right to appeal. That's number one. They could appeal it immediately. They don't have to wait to appeal. And there's some issues that could be quite easy to reverse her, depending on what she does, for instance, on suppression of evidence or the constitutionality of the special counsel. But I think this is where Judge Cannon has shown that when she can see that an issue might get her reversed, she has tended to say, well, I sort of agree with Donald Trump and I think the law should be changed, but I'm going to rule for the government. So she does this sort of weird dance where she sort of says things that are favorable to him, but ultimately rules for the government. So there is no ability to go to the Court of Appeals. So we have to see how she handles these issues. But there's no question that Jack Smith is going to be looking for those opportunities. But just to be clear, so everyone knows, it is hard to get a judge removed, and it should be hard to get a judge removed. You do not want a system where one side or the other just doesn't like the decisions that the judge is making, whether it's just the outcome, and says, oh, so I want a new judge. It has to be decisions that are so egregious that the court says, you know what, you are not the right judge to handle this, whether it's for you don't have enough experience, or whether it shows bias, whether it shows just fundamental misreading of the law. Those are the kinds of things that a court would look to before it took the drastic step of removing a judge.
Let's go back to the Supreme Court. We have so many questions about it, and there was a ruling today that it just seems so ridiculous. It made me laugh, and I'm probably misstating it and simplifying it, but it's a case out of Indiana called Snyder, where an elected official took money, as I understand it, after a decision was made about some public business. And the Supreme Court said, well, if he'd been given the money beforehand, it was a bribe. But since it's after the fact, it's a gratuity. It's essentially a tip, and that's okay. And given all the stories about Clarence Thomas and the gifts that he has been given by people who have cases before the court, who want to influence the court, it just seemed almost ridiculous on the face of it.
I'm going to read to you something that Justice Jackson but Justice Jackson today really outdid herself. I know I'm very nerdy, but I really would commend people to read Justice Jackson's dissent in the Snyder case and in the Idaho abortion case, when that sort of officially comes out, although on the internet you can find it. Again, her dissent, both of them are so beautifully written. But let me just read the first sentence of the Snyder dissent by, again, Justice Jackson. Officials who use their public positions for private gain threaten the integrity of our most important institutions. You do not think that Justice Jackson, Justice Sotomayor, and Justice Kagan, who all joined together, you don't think that they were thinking of Justice Alito and Justice Thomas when they wrote that?
It's a throwdown.
Yeah. And that was their reaction to this as well. The idea that this statute that Congress passed didn't cover rewards, and that is payments after the fact, not just payments beforehand. As Justice Jackson says, that's the language of the statute. It reads that you cannot corruptly take bribes or receive rewards. I mean, this is so it really points out the lie to originalists who say we just look at the text of the Constitution. We just look at the text of the statute. Here, Justice Jackson says, let's just go to the text of the statute. The statute says you cannot corruptly pay rewards. Period. She's like, end of story. We're done. I mean, she's like, how can you be an originalist and say that? And she calls it out. I mean, it's really quite remarkable.
Let's get to Justices Thomas and Alito, because the reporting from ProPublica and elsewhere has shown over the years that Justice Thomas took all kinds of help, support, not just for him, for his family, that's luxury RV trips on private planes, all sorts of, shall we call them gratuities now, to influence or to thank him for court decisions, and has only now occasionally filed remedial statements saying, yeah, this happened, I got it, but it wasn't a big deal. And Justice Alito as well has been truculent, I would say, about resisting any implications that he has any biases, either financial or political, in any of this. And the frustration with the court is simply growing as the court will concede, that part of the court will concede nothing, that they did nothing wrong.
So let me just make sure everyone understands the norms here, because I think in many other parts of the world, the idea that public officials take bribes is sort of unfortunately, part of their system. It just happens. And I'm not going to say that doesn't happen here, but it's a big deal when that happens here, and people get prosecuted for it. When you are a government official, if you're at the Department of Justice, if you are on a lower court, any court other than the Supreme Court, and I'll relate it to my experience. I was at the Department of Justice for over 20 years. I did not take a cup of coffee from anybody. It was not imaginable that that line would be crossed. There was nothing that you would take, even when there were some exceptions where it would be like if you had a long-standing friendship and it was relatively de minimis, you just didn't do it. When somebody said, "Oh, let me just take you out to dinner," or let me pay the theater tickets, you just split everything. And so this is where every single judge in the United States knows that what has been reported with respect to Justice Alito and Justice Thomas is fundamentally wrong. This is why you have this remarkable statement by Justice Jackson that I quoted from you. And you also have a failure to disclose that has now happened over and over again with Justice Thomas, where he is, as Senator Whitehouse has been so much a dog with a bone on this issue, and pointing out that it's still coming out in drips and drabs, and you don't see any effort to investigate whether he's been honest. These are all things that he has to sign and report to the government, and you're supposed to report those accurately. Receipt of those funds also has tax implications. You don't hear about anybody looking into that as well. I mean, it is the kind of thing that just, Pat, you pointed out the history of Watergate, but when Abe Fortas was on the bench, he had to resign pretty much in disgrace over allegations that are far less serious than the allegations with respect to Justice Thomas. And it is such a sign of where we are as a country, and the fact that a lot of what, at least I thought, were deep roots of norms and laws in this country, and I thought were instilled in the vast majority of us, seem to be very shallow roots that we still really have to fight for.
As you said, the dispassionate judiciary is one of the reasons that democracy functions, that people are not in the bag for one side or another. And is there no self-awareness on this court? Justice Roberts has refused to go to Congress to talk about it, and that may be a separation of powers issue. But is there no self-awareness of how much damage is being inflicted, not only on them personally, on the Supreme Court, but on every court in this country?
So, I think there obviously was some awareness because they came up with some ethics guidelines for the Supreme Court. And so, in other words, as weak as those are, and as there's no mechanism for enforcement, but at least that shows that they realized they had a perception issue and they had to do something. I don't think personally that Chief Justice Roberts understands how much this is undermining the Supreme Court and also his oversight. Because as Chief Justice, he has limited powers, but he needs to use them. He can't just order another justice to do something, but he can go to Congress. He can be more transparent. He can, in fact, figure out how he's going to assign cases if he thinks he has lots of levers that he can use to exert more pressure on justices who are engaged in behavior that is beyond the pale. And I really haven't heard anything from either Justice Thomas or Justice Alito that is in any way exculpatory. And in fact, many of their statements make the situation worse. And certainly when you look at what Justice Alito has said with respect to the flag flying, it in many ways, it's been called into question as to whether it was even truthful.
We've been talking about the court and its esteem and regard in the public eye. What are the consequences to the commonweal of a court that has really, it's like its feet are in sand at this point? One of our listeners, Stephanie, said they keep taking cases where the question is standing and not the substance of the case. They keep dodging these ethical considerations, and just down the road for the country, this seems to be a bad map into where we're going.
The way I have thought about this is, having lived through the Trump presidency at the Department of Justice and then on the Mueller team, various institutions that have posed some sort of safeguard or guardrail with respect to the executive were very much under attack, whether it's the Department of Justice or the media. Their whole reason for saying fake news was the idea that you shouldn't trust the media, that's the fourth estate should not be viewed as a guardrail.
And Trump said as much to Leslie Stahl before he...
Exactly. So the media was attacked for that very reason, that it could be a safeguard. The Department of Justice, I personally, but that's the least of it, but the prosecutors were attacked. It was clear to me that when you had 4 indictments, that the thing that was going to happen was that Donald Trump would attack the judiciary. And judges, and I'm going to quote from Liz Cheney, judges heretofore have held up pretty darn well. If you think about what happened on January 6th and the efforts of Donald Trump to say that the election was stolen, the court cases are all ones that on the merits, he lost, or his acolytes lost. The judges stood up to that at the lower court level and did pretty darn well, and being that check on the executive. In fact, in many ways, like the foolhardiness was going to court because they created a record of there is no fraud that would have changed the result. And I think what we're seeing now is, now that we have someone running who is under indictment in 4 cases, like any defendant, he is attacking as much as he can the process. But the unusual aspect is that you're seeing signs of weakening at the knees on the Supreme Court, judges like Judge Cannon, and mostly we're seeing a weakening at the knees of I think the thing that's most concerning, which is enablers. There will always be, and I think this group may know this in their bones, there will always be people like Donald Trump. That is not the issue. The issue is whether there's a system that's going to hold, and whether how many enablers will be out there. And to me, one of the things that's remarkable is looking at the people in Congress who know darn well what is going on and don't stand up for it. And so there are a lot of smart Republican senators who don't stand up, who are afraid or want power, who don't want to be voted out. And I think that is the real crisis in this country, as well as whether the Supreme Court and lower courts will hold in the face of this onslaught. I think that the Supreme Court has done pretty badly. I think that other judges have tried very hard. I think, as I said, I think that the New York judges have done very well.
You've tried people and gotten convictions who people said could never be tried and convicted. And a question I think we have from Ruth is about Trump's legal liabilities, whether he will ever be held legally accountable. He has gotten, as you point out, break after break, a consideration as a president, which would not be accorded to any other citizen, nor should they be accorded to any other citizen. And will he ever come to court and get his due? We've seen convictions in New York. Sentencing is July 9th. Who knows what's going to happen? But the intimidation, the fear, in a way, the collapse of some of those institutions lies all around him.
Yeah. So I think that we've seen the courts hold him civilly liable. We have 2 verdicts for defamation and sexual assault, where he has been found liable unanimously by a jury. There is a verdict with fraud. There's a criminal conviction of his company brought by the Manhattan District Attorney's Office a year and a half ago, where his companies were found criminally liable, 2 of his companies. These were criminal cases. And then, of course, there's the Judge Morrison case where there were 34 felony counts for crimes that have to do with a scheme to interfere with the 2016 election, where there was really uncontroverted evidence from the head of the National Enquirer that he, David Pecker, had an agreement with Donald Trump to catch and kill stories that were damaging to a political candidate and to foment fake stories with respect to his adversaries, both Republican adversaries and then Democratic adversaries. People keep on thinking, oh, this is a hush money case. That so diminishes the evidence that was presented at that trial, and it came from witnesses who are aligned with Donald Trump. But that's a long way of saying that those are all ways in which the court system has worked, and where you can say there has been accountability, and he is about to be sentenced. And we'll see what Judge Morrison, who is a really terrific, experienced judge who has had to endure all sorts of threats, and his family has had to endure all sorts of threats, which is, again, is remarkable because we're talking about somebody who used to be the leader of the free world, and the head of our justice system. So that again is such a sign of where we are. But at the federal level and at the Georgia level, there's no question that those cases, I think, certainly Georgia and Florida are not going to be tried before the election, and there is an extremely slim chance that there will be a trial of the DC insurrection case before the general election.
Let me slip in a couple of quick questions and quick answers, I hope. One from Bruce: why the founders and maybe subsequently didn't put an oversight body to the Supreme Court in the Constitution or legislatively since?
Yeah, I mean, so the idea is that there's checks and balances, and the check on the Supreme Court was going to be the executive and the Congress, and to some extent you can't create a perfect mousetrap. I mean, at some point you are relying on the integrity of individuals, and yet that additional oversight body, you would then have the issue of how do you have oversight over that oversight body. So it is tricky. I will say no one ever foresaw, for instance, that the pardon power that is given to the president and can use unilaterally would be used and wielded in a way where the president said, don't worry about committing crimes for me, because just go ahead and do it and I'll pardon you. You would think the reason I think the founders didn't think that's something they had to worry about is because they were thinking, well, who's going to ever vote for somebody who says that?
You mentioned earlier, and I want to get back to for a couple of minutes, that the world is watching the world is watching the judiciary as one of the foundational aspects of democracy and how it's practiced in this country and what it bodes for the rest of the world. What does it bode if we seem to be corrupt? The Snyder decision, well, if you pay him afterwards, it's only a gift. If you pay him beforehand, it's a bribe. All of this really does seem to chip away at the foundation of what this country is supposed to represent.
Absolutely. Um, there are certain countries, Russia, China, who have to be licking their chops saying, that's great, we're for sale. We have no principles, we have no morals, we have no rule of law. We're going to devolve into a Russian system where everything is transactional. There's no acting out of principle. It is severely destabilizing currently of what are supposed to be our allies and still are the Five Eyes, most of Europe, many countries in South America, to have this destabilizing effect. And obviously, Ukraine is so on the ballot, but Ukraine is such a symbol of what is on the ballot. It's both real and with real people dying for democracy, and it is a symbol of what is to come if this country is going to become completely transactional, where the president, who doesn't seem to understand the idea that people would act out of principle.
This election seems to be all about that, and so much more than just one person in the White House.
Absolutely, I really think that is right, and I do think that it is. It's hard because we have an immediate situation where everyone's focusing on one person, and that's right to be thinking about the things that would come, that we know would come because we've seen it before from this particular person, but it is something that we know we're going to have to live with beyond him, because to me, the wake-up call from the first Trump presidency was the idea of things that I took for granted about our democracy are things that are really not instilled in Americans in the way that I thought they were. And that to me is something that is sort of more of a long-term issue for this country. If we get to the sort of, if Trump is not elected, we still will have that problem.
We try to end on something upbeat for a minute or two for the last, so maybe you can give our listeners, and I hope you'll come back because there's so many questions still awaiting you. People are engrossed and concerned and very much looking forward to hear what you have to say. But if you could give us a minute or two of something that seems a little upbeat and hopeful that we can hold on to.
Sure. So, I think I attended much of the New York criminal case. And one of the things I really so wish that had been televised, or at least there was an audio version. And the reason is the judge overseeing it was the platonic ideal of what you would want for a judge. He was fair to both sides. He ruled for and against Donald Trump, for and against the state. The prosecution was represented by the very top, most ethical, experienced people. They handled themselves well. They conceded where they needed to concede. It was what you wanted to see prosecutors and how you wanted to see them behave. The defense lawyers were really good. Some better than others, but you saw a defendant getting due process, getting all of the rights that you want to see in our country a defendant have. And then finally, you saw jurors, average people, take their oaths seriously. I'm sure many people who are listening have served on juries. I've served on a jury. I was just so impressed with how seriously everyone took their responsibilities. I'm always upset when I hear people denigrate jurors. I think it's so dismissive and elitist. And so I think is my uplifting sentiment, is that you can really see justice done.
We will take that and hope that you'll join us again. Thank you for this first appearance on America at a Crossroads, Andrew Weissmann. And your book, of course, is available. Look forward to seeing more from you and hearing from you. Thank you so much.
Thank you.
Thank you to everyone who watches and supports this program. You can see there a list of the upcoming programs we have, including a special one analyzing the debate taking place, as you know, tomorrow early evening California time. Check your local listings, as they say, to be able to watch this vital presidential debate. I'm Pat Morrison. Thank you all for watching.